Hi friends, I'm saitej pusarla. I have cleared my CA final second group and I'm pursuing financial risk management and I possess National Institute of Security Markets of SEBI certifications too in derivatives, research analyst and merchant banking. So, and I'm very much passionate to teach corporate laws for the CA final and chose superprof.com as a platform to deliver my content to as many as students as much as students as possible. So let's start with the important chapter meetings powers of the board in corporate law, which is regularly tested area in CA final law paper. Remember one thing, that if you have read the sections very deeply and analyzed the sections very deeply, then nobody can stop you from scoring exemption. And if you score exemption in law, then the burden on other subjects get decreased, as you all know. So definitely law is a non-core paper for CA final, as it's a core paper for company secretaries and lawyers, but it's not core non-core subject for chartered accountants. Hence, it won't be given very tough. The law is tough only, but when you read the provisions thoroughly, obviously you can tackle, because here scope of applying the mind is very less when compared to other accounts and strategic financial management subjects. So let's start with board meetings. So I will proceed in this way. What is board meetings? What was said in the provisions of the act related to board meetings, and why it was incorporated? So friends, if you know why the act incorporated some provisions related to the board meetings, then it will be very easy for you to register the things which was said in provisions. Because for example, I can say that board meetings can be conducted once in 3 months, and in yearly of one financial year 4 board meetings has to be conducted, otherwise penalty will be levied on the companies act. Matter over. But it's not the right way to learn the things. Okay, so we'll proceed in this way for important terms. What is board meeting, what was said in the act related to board meetings, and why it was incorporated. So when coming to the what is board meetings, it's a group of directors of the company meet together to discuss about the affairs of the company and their future acts, to exercise their duties, their powers, and they have to discuss about the things, how they can build the business, or and also some of the decisions has to be taken in board meeting, that how much has to be dividend has to be declared, how much bonus has to be given, how much buyback can be made. So and approving the annual financial statements, some of the things are there where board has to take the decision and it has to approve. So this is board meetings. Board meetings means it's a collection of directors to discuss about certain things. The certain things will be discussed later. I will tell you. I will tell you in how many ways board meetings conducted, and how many ways the board meetings get conducted, and how many days notice has to be given, and regarding what all the things get discussed in board meetings, regarding all those things get discussed later, and what was incorporated in the act. See, this is very important. See this. For companies, every company has to make board meeting once in 3 months and gap should not be more than 120 days from one meeting to another meeting. Okay, and for section 8 and 1-person companies, this is different. They has to meet once in 6 months and gap should not be more than 90 days. Okay, see this. For each and every company, that is for public company or private company, once in 3 months they have to meet. That means 4 board meetings has to be held in one financial year. Whereas coming to section 8 and 1-person companies, 2 board meetings has to be conducted. Okay, now why the provisions related to board meeting was incorporated? Because shareholders are putting responsibility on the company and company is putting responsibility on directors. Directors are ultimatum, which means they are superior. Whatever the decision they take, nobody is there to question them. So the act supervenes the powers of the directors. So if this type of provisions are not there which curb the directors functioning, which have superior control over the functioning of the directors, then they won't meet regularly. Then they don't have much care to discuss about the company's acts because their money was not involved. Shareholders' money is involved. Hence, to put an observation to supersede over the functioning of the directors, this frequency of the meeting has to be held, and regarding this frequency the act has incorporated some provisions. So this about the board meetings. And now let's start with quorum. So friends, what is quorum? What means the minimum number of directors so what minimum number of directors to be presented when general meeting or board meetings were held. And here we are talking about board meetings, then quorum related to board meetings. Okay, so what is quorum means? Minimum number of directors has to be presented when board meetings were held. So what was incorporated? What? Again, for companies and for section 8. Friends, I think you all being noting down the points which I am teaching on the board, which are very important and will be surely tested. The numericals are very much tested in the Companies Act, Companies Law paper these days. So, company, what is quorum? 1/3 of total directors or 2, whichever higher. I'm writing shortcuts. This TD means total directors. Okay, and section 8, for section 8, 25% of total directors or 8, whichever is lower. You will make note of this, that for other companies it is whichever is higher, 1/3 or 2, whichever is higher. For section 8, 25% of the total directors are 8, whichever is lower. So what is quorum was discussed, and what was there in the provisions of act related to the quorum was discussed, and why. If the provisions related to quorum was not incorporated in the act, what will happen? Just one director present to comply with the provisions of the act, and he said that yes, I am complied with the act, and board meeting was conducted as per the regulations of the act, the company is not liable and I am not liable for the penalty. No, they don't need that. They just want majority of the people's, majority of the directors participation in the board meeting. Hence, quorum was, the provisions related to the quorum was incorporated in the act. So this is about the quorum. Let's see about the content which was given in the institute material slides about these meetings and quorums till now. Meetings. And these learning objectives are meetings, adjournment, notice, time and place, quorum and interest directors, resolutions, committee, participation, power of directors, disclosure of interest, sole selling agent, summary. We will discuss one by one. Okay, first, meetings of the board. As we said that frequency of the board meetings once in every 3 months has to be conducted. Friends, do you remember for section 8 companies and 1% companies, once in 6 months? Okay, this was there because for companies 3 months and for section 8 6 months, because in section 8 and 1% companies most of the shareholders money was not involved, and also they won't be having much responsibilities, much functionalities as much as other listed companies and private companies are having. Hence, they need not meet regularly, they need not meet frequently. Hence, for companies 3 months, for section 8 6 months. I'm repeating the same content twice or thrice because these are numericals. These should get registered in your mind. Meeting adjourned for want of quorum. Okay, let's discuss about this thing. Quorum. Suppose 10 matters has to be discussed. See, I will give you one example. 1 minute. Suppose 10 items has to be discussed in board meeting. Quorum will be seen in the first stage itself. When the directors are present in the board meeting, first step is counting of quorum, and 10 items has to be transacted, and for 6 transactions the quorum is present, that is 1/3 of total director or 2 whichever is higher is present. For remaining 4 transactions, they left in the middle. Some of the directors left and only one director is present. Let's assume. Then these 4 transactions are not valid. Only these 6 transactions where the quorum was presented only valid. Even the quorum was made in the first stage itself for 10 transactions. Even after conclusion of the transactions also the quorum should present. If after completion of the transaction, if the quorum was not present, then those transactions are invalid. Okay, this you should make note of. So, see this. Meeting adjourned for want of quorum means, as we said that 1/3 or 2 whichever is higher director has to be presented for want of quorum, and when counted for the quorum, if such respective number which was prescribed as per the provisions were not attended, then the meeting will be automatically adjourned for next week on the same day, provided that day should not be a public holiday. Actually, unless articles provide, the act did not say when the adjourned meeting has to be held. Okay, and for conducting the board meeting, at least 7 days prior notice has to be given to each and every registered director. So For adjourned meeting, the same notice need not be given to each and every director, provided if there is no change in the location. If there is any change in the location, time, date, or the day for the continuation of the adjourned meeting, then fresh notices has to be given to each and every registered director, provided 7 days prior gap should be there between the adjourned meeting to be held and the notice of giving of meeting. So, see, not on public holiday. Is director bound to attend the meeting? Directors are legally not bounded to attend the meeting, provided if it will come later that if they won't continuously come or attend for the board meetings either through video conferences or through coming to meetings physically, then it will be a guilty of breach of duties and they will be disqualified directors under section 167. That will come later, but a director should present at least once in one financial year to not to be disqualified as a director. If in entire 12 months, that is in entire financial year, if they don't present as a director, then he will be disqualified from the directors. And notice of meeting, as I said, that notice of meeting has to be given in writing to each and every director who has been registered. So you have to make note of one important point is that some of the directors show their inability that no, we can't attend the meeting, we are going on a business trip, I am going to honeymoon, like that. If they say, even to that person also you should give the meeting. But actually what we think that okay, anyhow they showed their disinterest in attending the meeting, so we need not send. No, act won't leave you. Act will penalize the person who don't send the notice to the director who showed his disinterest in attending the meeting. So one line point is, even the director showed his disinterest to attend the meeting, you have to send the board meeting notice. And 7 days, at least 7 days gap should be there between the sending of the notice and the meeting has to be held. So the notice can be sent either through electronic means or through post. What will happen if notice is not served? As I said that it's the responsibility of the chairman or the company secretary who takes the responsibility of sending the notices to the directors. They will be penalized. No, where a director goes abroad for 3 months and an alternate director has been appointed in his place, then to whom should the notice of board meeting to be given? So here one term has came, that alternative director. What is alternative director? I will discuss now. As it came here, I will discuss now. What is alternative director? Alternate director. If original director who goes to abroad for more than 3 months, that is, original director has said to the board of directors that I can't attend the board meetings, or I can't take the responsibilities, or I can't be involved into the functionalities of the company for 3 months as I am going on a tour. And in place of that original director, alternative directors are appointed. Okay, original director don't have right to appoint alternate directors. The board of directors, if they feel like if original director was not there, we can't make our functioning, the burden will be increased on us. If they feel like that, then they will appoint this alternative director, provided articles should vest this power to the board of directors. That is, in articles it should be there that board of directors has the power to appoint alternate director when original director goes to abroad for more than 3 months. This about the alternate director. And coming to this question, yes, board of meetings notice has to be sent to each and every director whether he has shown his disinterest, or to the directors who has went on an occasion for any other person to abroad. Then means the notice has to be given to alternate director also, because one more provision related to the alternate director is when original director attend, alternative directorship comes to an end. And also one of the way a director can participate in board meeting is through video conference. The video if the director who has participated in board meeting through video conference is also counted for the board meetings quorum. So whether it should be to original or to both, each and every director the board meeting notice has to be sent. Okay, time and place of board meeting. The act did not put any restrictions on the company. Here only you should conduct the meeting, at this place only, at this time only. Act don't want to interfere in each and every aspect of the company. Hence, it's the decision of the company where to conduct and what time to conduct. It's as per the convenience of the directors. Can board meeting be held on public holiday? Board meeting can be held on public holiday and also even after the business hours also, provided, as we discussed earlier, that if quorum was not formed and the meeting was adjourned, then the meeting will be adjourned to next week on the same day of the next week. So can board meetings be held on public holiday? If on public holiday board meeting was conducted and the meeting was adjourned due to want of quorum, and that adjourned meeting should not be held on public holidays. That is, see this, I will explain in board. Board meeting not on public holiday, adjourned. If adjourned, then it can be on public holiday. Board meeting was conducted on public holiday. If urgent, it should be on not on public holiday. So about quorum, as we discussed that 1/3 or 2, whichever is higher. 1/3 in the sense, suppose the directors are 7 here and 1/3 means 2.33. We should not take lower because 2.33 should be rounded off here. Hence 3. Total number of directors should be presented for want of quorum is 3. Must be present at the time of transaction, as this example was discussed earlier. Directors present and vote will be considered. Okay, this one. Obviously, I said that 1/3 of the total directors or 2 directors, whichever is higher, should form the quorum. And total directors means not all the directors who are working as a directors in the company, who present at the meeting and who has participated in voting, whether in favor of the transaction or against the transaction. They should do some act in relation to that of the transaction. Even if they sit even if they sit silent, then they won't be considered. You suppose 10 directors, total directors of the company are 10, only 8 directors are present. In 8, only 6 participated. That means some voted against, some voted in favor. Those 6 are only considered for want of quorum, that is 1/3 calculation. The 6 are only considered. Okay. Articles. Okay. Quorum. This about everything was discussed about all these things. Interested director. What interested director? I have to discuss about this term. What are the interested directors? Okay, but before discussing about the interested directors, let's discuss about already discussed topic of whether board meetings can be conducted on public holidays. Yes, board meetings can be conducted on public holidays, but if that meeting was adjourned for want of quorum, then adjourned meeting should not be held on public holiday. That point you should make note of it. And quorum, this point was already discussed. For calculating the quorum, total strength of directors is to be derived after deducting the number of directors whose offices are vacant. That means, as I already discussed, that only the number of directors who has presented for the board meeting and who has participated in the transactions. That means the directors who has presented and remained silent, those directors won't be considered. The directors who has participated in favor, directors who has voted in favor, or the directors who has voted against the transaction, both the directors has to be taken as consideration in determining quorum. Okay, that was the point said here. And some important points you should make note of it about the board meetings. That act says 7 days prior notice has to be given before the board meeting. Thus shorter notice is possible. Yes, shorter notice is possible because the situations may come that directors has to take the immediate decisions. They can't wait for 7 days for, but they have to comply. If they wanted to conduct the board meeting immediately, they have to comply with this provision that independent director should present to that board meeting. And if independent director was not attended to the board meeting, as independent director won't be restricted to one company, he will be independent director in many of the companies. Hence, in shorter notice period, there won't be possibility for him to attend the board meeting. Then the transaction can be made if he ratifies the transactions which are taken place in the board meeting. Then it's a valid meeting. Okay, so, and as I said, that notice of board meeting has to be given prior to 7 days period. And what has to be stated, whether the agenda to be discussed, what are the things to be discussed in board meeting should be stated in the notice or not. Actually, act did not put any provisions whether to write or to state about the agenda, the things which are to be discussed in the board meeting, but it will be considered as a good secretarial practices in saying about the agenda in advance through the notice. But act did not say you should compulsorily put up the agenda in the notices, but that was not there in the act. Act did not put any restriction. You should remember that it will be tested area. And coming to the quorum, important point in the quorum is, actually act says 1/3 of the directors or 2, whichever is higher. But if you have amended in the articles that we want for larger quorum, we want for more quorum, that means not 1/3 of the directors, you have written the 2/3 of the directors, then articles prevail over the act. That's about your decision. That's about completely about decided based on the articles will be superseded when compared to this act. Okay, coming to interested directors. Okay, let's start with interested directors. So let's start with interested directors. So before knowing what all the provisions were incorporated in the act related to interested directors, you should know what are interested directors. What are interested directors means the director of the company, either individually or together with the directors in the company, holds more than 2% of the voting power in other company, then he will be said as interested director. Director either individually or all the directors together hold more than 2%, then he will be considered as interested director. And if the director is a partner in a firm or a member of any company, then if the company is going to enter into any transaction with that company or partnership firm, then he is to be treated as interested director in it. And the person, the director who is a promoter or manager or CEO in any other company, then he will be interested director. So again, the director either individually or together holds more than 2% of the voting power, and the person who is a partner in a firm or a member in a company or who is a promoter or manager or a CEO. So this is interested directors. Okay, what was incorporated in the act? What if any of the interested director, that means if any of the director who is being appointed or appointed as a director in the company, he has to disclose his interest that he is holding more than 2% voting power, and where he is partner and where he is a member, in what all the companies he is a promoter or manager. All the details he has to submit to the company in the board meeting which is held after he has become interest director, after he has become the director. Sorry, okay, he don't have all these interests when he appointed as a director, but after he has appointed as a director, then he became interested director. That is, after becoming a director, he purchased 2% of the voting power, 2% of shares in other company. Then the interested director has to disclose this fact in the first board meeting which was held after he has become the interested director. If interested director won't disclose his interest, then company can cancel the contract if it has entered with these type of companies or firms. So it's its own discretion of the company whether to continue or to cancel the contract, because this was made. Why? So we discussed what is interest directors and what was said in the act related to interest directors, and let's discuss why 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 this was incorporated. Generally, it's also like related party transactions. We'll cover that later. What will happen, when we go to any shops, we we generally go to the shops which we know mostly from our childhood, or our parents know them well, because they will give us more discounts. In the same way, the interested directors will have to, if the company enters into any transaction with these firms, generally if they sell, they will sell at high discounts. There is a possibility that they can sell at high discounts because all these are related to interested directors. Or if they buy the products from those companies, those related companies, then there is a possibility that they can buy at a huge prices. Because, for example, if x y x is holding in x, a is holding more than 51% of voting power, like let 49% of voting power. Let's not make it complicated. 49% of the complicated. X bought goods at a price of 1000 crores, which its actual value is 500 crores, but there is a possibility that bought at 1000 crores, which means 500 crores profit to y. Indirectly, this a of x is getting benefited, and this they don't want to encourage. That means even if they can make profits, they just wanted to show the genuinity of the transactions to the public. If this was not disclosed, then there is no possibility for the shareholders to make aware that these are interested director related companies and the transaction happened between these type of companies. So one line summary is, if interested directors has disclosed their interest, then shareholders can make aware that yes, these are the related companies of interested directors, and the transactions entered by this company with those companies should be analyzed deeply, whether the transactions taken place between them are genuinely made or no genuinity was there in those transactions, just to make the shareholders aware. These provisions were enacted. This about the interested directors. And one more thing is, the interested directors should not participate in the board meeting while the decision taken by the board whether to enter the contract or not. And see this. The interested directors should not participate in the transactions which the company is going to enter with these type of interested directors companies. That means they won't be allowed to participate in the board meeting. Decisions can be taken by the non-interested directors. And some of the situations has to be explained related to the interested directors now. Suppose more than 2/3 of total directors are interested. More than 2/3 of the total directors are interested, then the remaining directors or two, whichever is higher, should form the quorum. For example, out of 12 directors, 2/3 means 8, means 9, 8 directed 4 are non-interested directors, or 2, whichever is higher, should form quorum. Okay, these 4 are non-interested, it is higher, and the 4 directors can form the quorum. Suppose take this example, out of 12 directors, all the directors are interested directors. or all the directors are interested directors, then two options are available. Then company can appoint additional directors who are non-interested directors, or the matter can be put up to general meeting. Extraordinary general meeting can be called if all the directors are interested. This is one of the important point you should make aware of it, that if all the directors are interested, then directors can appoint the additional directors who are non-interested in the transactions, or they can call for a extraordinary general meeting. So, and this point, if more than 2/3 of the total directors are interested directors, then the remaining directors or the two, whichever is higher, should form the quorum. So this is about the interested directors. So let's see the slides now. If all the directors are interested in some transaction, then the board can call an extraordinary general meeting. This was discussed. The number of interested directors exceed 2/3 of the total directors and minimum 2 remaining directors present at a meeting, quorum will be satisfied. This is also discussed. This is example which is not valid. Actually, as I already explained this one. Private company respect of any contract or arrangement thereof. Okay. Minutes. I think this need not be discussed. Minutes means what all the transactions entered, and you will be having in audit that working papers, because everything done has to be put up in writing that the meetings were conducted. In the same way, the meetings are conducted, and the minutes are the proof that these are the official records that the transaction has been taken place, how the meeting was held, and it acts as a proof that what was happened actually in the board meeting. Then it should be recorded in 30 days, and it will be signed by the chairman, and it will be maintained by the chairman. This is very small provision, and this is important. Resolutions can be passed at the board meeting, and resolution can be passed through circulation. We have already discussed how the board meetings can be conducted. The board meetings can be conducted either physically by attending the directors to the place where they have already fixed, or through video conference. Both are treated as board meetings, but resolution passed by the circulation is not counted as a board meeting. Generally, previously, now itself we have discussed that if the board meeting, the board has decided to transact any urgent businesses, a shorter notice is allowed. And also, every time they need not meet physically to discuss about small issues will be there, and they need not conduct the meeting because it costs a lot of money to the company for conducting the board meeting. So this resolution by the circulation was incorporated in the act, that what all the things has to be discussed will be made as a draft and has to be sent to each and every director registered with the company, and they vote against or in favor of the resolution, and they send it to the company back. And if 1/3 of the total directors, remember this, 1/3 of the total directors decided not to decide this transaction based on resolution by circulation, and it has to be discussed in the board meeting, then it won't be discussed through resolution by the circulation. It has to be put up at the board. If less than 1/3 of the total directors raised objection, or nobody raised the objection, then the resolution will be passed. So this is one of the alternative way to decide the transaction of the businesses to be entered by the company, or the items to be discussed in relation to that of the company. If this was not there, they have to meet each and every time for discussing any other matter. Even for the small matters also they should meet, which costs a lot of money to the company. So this is about resolutions, and we discussed through the slides. The resolution passed at the board meetings, and these are compulsorily made only at board meetings for filling the casual vacancy. We can discuss about this casual vacancy later, but for filling the casual vacancy, this can't be, a resolution can't be passed in relation to filling the casual vacancy through circulation. And also for appointing the MD has to be appointed only at the board meeting, and also for making the investments in companies. For this also, board has to meet physically or through video conference. These are the highly complex decisions, complicated decisions, and you should note that resolution by circulation is made to transact only small items. For bigger items, there is no alternative, they should meet physically. Okay, and this procedure was explained. Let's read it again. Send the draft resolution in duplicate together with the necessary papers to all directors then in India. See, if you compare with board meetings and board meetings and resolution by the circulation, in board meetings you have to send the notice, but you need not state the agenda compulsorily as per the act, but stating the agenda which are to be discussed in board meeting is considered as a good secretarial practice. But resolution by circulation, you should compulsorily state the transaction, the items to be discussed through draft. Okay, resolution passed by circulation, signed by the director or approving the resolution. Yeah, this was also discussed that resolution passed by circulation shall be placed before the next board meeting for confirmation. There must not be any objection from not less than 1/3 of the total number of directors of the company for the time being, requiring that such resolution under circulation must be decided at a meeting. As I already said that if 1/3 of... So let's discuss about the powers of the board first. These are the powers: to call for monies, to give loans or guarantee, to invest funds, to borrow, to issue securities, to approve financial statements and board meeting. These are financial statements and board report. Okay, what is to call for monies means unpaid calls will be there. Out of share capital, paid up value is 8 rupees, and the actually capital has to be received in 10 rupees. 2 rupees is the unpaid capital, and this has to be received, and this call can be given by board of directors. When the unpaid call has to be called, will be decided by the board of directors. This is to call. And to give guarantees or loans to individual or to other companies or firms, to invest funds in other companies, to borrow from financial institutions or from other companies. So you have to make note that these three are the only powers. These are the powers: to give loan, to invest funds, to borrow. These are the three powers which can be delegated. These are the powers can be delegated to MD or principal officer or committee of directors. So once again, powers of the board has many powers: to diversify the business, to issue shares, to call for the monies, to approve the financial statements and board reports, to give loan or grants. They have multiple powers and multiple functionalities, but all their powers can't be delegated to each and everyone like bread and biscuit. Okay, the act has enhanced only the three powers: that they can give loan or guarantee, invest funds, borrow. This can be made not only by the directors when the board has taken a unanimous decision, that means all the directors, at least one director also should not raise any objection for this delegation. If they has delegated these powers to MD or committee or principal officer, for all these three powers, once again revise it, because to give loans or guarantee, to invest funds, to borrow, all these three powers can be given to MD or committee or principal officer. Why I'm repeating these many times? Because it gets registered in your mind, okay? And other powers can't be delegated, only these three powers can be delegated. For these three also another exception is there. We'll discuss this later, but after discussing this one, okay, let's discuss about these exceptions. Okay, so exceptions are loans, guarantees to be given to outsiders. See video. See, loans or guarantees or investment made in other companies if exceeds 60% of the paid up capital or free reserves or 100% of the free reserves, whichever is higher, then prior approval of shareholders has to be taken through special resolution. Actually, see, if the loans or guarantees or investments where to whom and what amount has to be given, to whom the loan has to be given, and how much funds can be invested in the company can be decided by the board, or if it was delegated, then the delegated authority, that means if it was delegated to MD or principal officer, then they have right to decide to whom and to what amount the loans or investment can be made. But if exceeds 60% of the paid up capital or free reserves or 100% of the free reserves, whichever is higher, then special resolution has to be passed. This is one of the exception, you should remember this. And other exception is if borrowings are made, that means I will explain this through example. Paid up capital 100 crores, free reserves, that means securities premium, general reserve, and this capital reduction reserve or revaluation reserve are not considered as free reserves. Free reserve is 100, total 200. Already borrowings made is 150, and proposed borrowings is 70. Already borrowings is 150 and proposed borrowings is 70, total 220. Here total is 200. That means 100% of the paid up capital and free reserves exceeding aggregate borrowings, that means proposed borrowings and already taken borrowings. Then for this excess of the 200, that is excess of this 20, special resolution has to be passed up to 200 crores, because this is less than or equal to the paid up capital and free reserves. Up to 200 crores, either board or the MD, if power was delegated, they can take the decision. If it exceeds the 200, then special resolution has to be made. It means aggregate of the borrowings exceeds the 100% of the paid up capital. And one exception is term loans will not be calculated. Term loans means short-term loans. These won't be calculated in consideration of the borrow. So let's discuss the slides quickly. This is committee of the directors, which will be constituted by the board. That means this will be constituted just to delegate the powers. That means they can't exercise all the duties. It will be burdensome for board to taking the decisions or to do any functions of the company. Hence, a committee of the directors will be constituted and some of the powers will be delegated to them. Committee. This is about the committee, and which is not much important. Participation by the directors in meetings through electronic mode. As I already said that for calculating the quorum, for counting for the purpose of the quorum, either the director can present physically, or if he has participated through video conference also, he can be counted for the purpose of the quorum. Okay. And if any of the person wanted to participate through the video conference, has to give his intimation that he wanted to participate through this electronic means before itself. Yes, and they can say that there is a provision in the act that we can participate through video conference also. Even if we participated through video conference also, we will be counted for the purpose of quorum. No, we need not attend for the meetings physically. No, but there is another exception for this one is, even if he has participated in video conference, even if he has counted for the purpose of the quorum, he should attend physically at least once in a year. Otherwise, everyone will say that okay, we will participate through the video conferences, that we don't attend the meeting physically. So they should meet at least once in financial year. Hence this exception was made. Okay, these powers of the directors was already discussed, that these are the powers can be exercised collectively by the board. One person don't have superiority over the powers of board unless those are delegated. All are equal. Okay, these are the powers as we already discussed, that to make calls, to issue debentures, to borrow money, to invest funds, to make loans. Have you noticed this? These 3 points, to borrow money, to invest the funds, to make loans, these powers can be delegated to MD or principal officer or committee of directors. Okay, other powers, these are the they can fill the vacancy, they can make a donation to the political parties. The donation to the political parties has to be made less than or equal to 7.5% of the 3 years average net profits. They can't make excess contribution to the political parties either directly or indirectly. If they make the donation excess to that of the 7.5% of average of the 3 years net profits, then the persons will be penalized. Okay, it can only be exercised with the consent of the company general meeting. See this: sell, lease or otherwise dispose of one or more undertakings of the company. This undertaking, what is undertaking? What is undertaking means, out of the total assets of the company, if any of the companies having more than 20% of total assets or 20% of net worth, or any undertaking which generate more than 20% of income, then that segment is called as undertaking. I repeat, if suppose the company will be having many segments, many undertakings, one will manufacture shoes, one will manufacture socks, and like that many segments will be there. One manufactures chappals. Out of all the undertakings, when we prepare the consolidated financial statements, in that consolidated financial statements, if any of the undertaking individual financial statements, net worth or income or its assets contribute more than 20% of its consolidated financial statements, then it will be considered as an undertaking. So that can't be exercised, that decision can't be taken by the board, selling, leasing or otherwise disposing of one or more undertakings of the company. This is one of the exception. And remit or give time for the repayment of any debt due by a director. Loans can't be given to the director as per the provisions of the act, but a debt can be given. That means the difference between loan and a debt. Loan means without any consideration, we are just giving as a loan or a guarantee or a security to the director. Debt means it is in the general nature of the business of the company. That means they are into the construction business, and how they sell the flats, in the same way they sold the flats to the director. Generally they give the flats in the process of installments, like all the amount has to be settled in 12 months. 1 month installment was not paid, and that is called as a debt, and that debt is allowed as per the Companies Act, but loan should not be given to the director. So to give time for the repayment, then it is giving the or extending the time can't be decided by the board. Invest otherwise in trust securities, the compensation received in respect of compulsory acquisition needs to be borrowed. This point was discussed. Okay, is MD to grant loans or give guarantees, provide securities in respect of the loans? Yes, as it was discussed. Company authorizes MD to give donation to charitable trust in which any of the director may be interested as trustees. See, 5% of the average profits of 3 years can be made as a donation to the charitable trust. If excess wanted to be given, then general meeting has to be held and permission from the shareholders has to be taken. That means up to 5% need not take the approval from the shareholders, but if it exceeds the 5%, then ordinary resolution only, not special resolution, ordinary resolution has to be taken. So the example was given. A public limited company wants to donate 40,000 to a hospital which is established exclusively for the benefits of its employees, whereas the company has suffered losses since last 5 years. Means average 3 years net profit is 0 and it's contributing 40,000, means exceeding the 5% of the net profits, then ordinary resolution has to be passed. Power to appoint or employ person as its MD or yes. To appoint a MD, unanimous approval has to be made. No one should make any objection that we don't want him to be appointed as a managing director. If one raises the objection, then he can't be appointed as a managing director. And one important point is, to become a managing director, he should be a director, but to become a manager, he should not be a director. And managers can be only one in the company, but MDs can be more. And manager and managing director can't be together in a company. Disclosure of interest by directors in contract, as it was already discussed that according to section 184, a director who is directly or indirectly interested in any contract, whether actual or proposed, with the company or by the company, must disclose his interest at the meeting of the board. He attracts penalty if he won't comply with the provisions. Yes, it was already discussed that how he will disclose. He disclose in a general meeting, and this notice will remain effective for 1 year, 1 financial year. Again, he can't in next year also he should show his interest that in what all the companies he was interested. He can't think that okay, in last year financial year I have submitted all the details, no, in this year I need not submit. Not like that. In every financial year he has to submit his interest in the companies or the firms where he has interested. Okay, this was also now actually if if one director either individually or together holds more than 2% of the voting power in other company, then he will be said as interested director. It was discussed already. But if he has less than 2% holding, then he need not disclose his interest by the interested director. This was also discussed that can't participate and vote, not to be counted for the quorum. Voting by an interesting director does not invalidate the contract or arrangement. And friends, you should make note of one important point here is this is applicable only for the listed or unlisted public companies. But when coming to the private companies, they can disclose their interest and they can participate and they can vote in favor of the contracts to be entered. That means for public or private companies, the interested directors can't participate and vote and won't be counted for the quorum. But for the private companies, they can disclose their interest and they can participate and they can vote. They will be counted for quorum also. This is all summary. We discussed these powers of the board of directors, holding of board meeting, notice of the meeting, time, quorum, resolutions. Okay, let's go back to the content what we have discussed and let's see whether everything was covered or not. And let's have a quick recap. Yes, friends, this is very much important. Focus here. Meetings of the board of directors. Meetings of the board of directors has to be conducted once in 3 months and gap between one meeting to other meeting should not be more than 120 days for public companies and once in 6 months and gap between one meeting to another meeting should not be more than 90 days for section 8 and 1% companies. Adjournment for want of quorum. Quorum means 1/3 of the total directors or 2, whichever is higher. Quorum means minimum number of directors has to be presented when board meeting was held. Adjournment for want of quorum. This means if any meeting was adjourned due to want of quorum, then the meeting will be held on the next week of the same day, the same time, the same place. If there is any change in the place of the original meeting, then a separate notice has to be sent to all the directors. Notice of the meeting. Prior notice of 7 days has to be given to each and every board of the directors, and if they wanted to give a shorter notice, one independent director has to present at the board meeting, and if independent director could not attend the board meeting, at least he has to ratify the transactions which has taken place in the board meeting. Time and place of the meeting, this was not decided. This act did not specifically say at what time and what place the meeting has to be conducted. It was as per the convenience of the board of the directors. Quorum was discussed. Interested directors. Who are the interested directors means director either individually or together holds more than 2% of the voting power in other company, or promoter or a CEO or manager of another company, or if he is a member, or he is a member of a company, or he is a partner of any firm. Then he becomes the interested director. Then he has to show his interest. He has to disclose his interest in the board meeting held. If he is not disclosed his interest, he will be penalized and the contract entered by the company can be cancelled. Resolutions. Resolution by board meeting, resolution by circulation. What is resolution by the circulation? Not all the transaction has to be discussed in the board meeting. which is a very high which costs a lot of money to the company. Small issues can be discussed, or which are not focused areas can be discussed through resolution by the circulation. A draft has to be sent, what all the things has to be transacted, and if more than 1/3 of the directors has said that we don't want to discuss these items through resolution by circulation, please put these things in board, then those things will be discussed in the board meeting only. Committee of directors and meeting thereof. Committee of the directors, these are constituted by the board. Why the board constitutes this committee of the directors? To distribute the work, to distribute the functions, to distribute the duties, to lessen their burden, so that they can function effectively and efficiently. Participation in meeting through electronic mode. Yes, everyone, all the directors have the right to participate through video conference. Subject to, once in financial year they should attend physically to the meeting. What are the powers of the directors? To call for the monies, to invest, to give guarantee, to give securities, to borrow monies, to raise share capital, to issue bonus. All these are the powers of the directors. Out of those powers of the directors, some of the powers can be delegated to MD or principal officer or committee of the directors. Only 3 powers can be delegated: investing the funds, giving loans or guarantees, or to make borrowings. And in that also some exception, that is up to, for loans or guarantees given or to be investments made in other companies, up to 60% of paid up capital plus free reserves, or 100% of the free reserves, whichever is higher. Up to that limit only they can make loans or securities, loans or guarantees or investments can be made to other companies. If it exceeds, this special resolution has to be passed. And one more thing is, if total borrowings, already taken borrowings plus proposed borrowings, if it exceeds 100% of paid up capital or free reserves, then special resolution has to be passed. If it is less than 100%, then they need not go to shareholders. Disclosure of interest, so summary. So let's discuss multiple choice questions. I think you can solve these questions without any options. We discussed each and every section very thoroughly. Multiple choice questions. Board meeting can be held. Where the board meeting can be held? Let's think. There is no restriction in the act where to board meeting has to be held. It's at the discretion of directors. See the options. At any place as per the convenience of the directors. Okay. Section 173 requires the board to meet at least once in every 3 months. 3 months. Okay. General notice by an interested director showing his interest will remain effective up to 1 financial year. For next financial year, he has to disclose his interest. He has to give notice that wherever he has interested freshly for the end of financial year. Notice the end of the financial year, up to 1 financial year, not 1 full year, up to financial year, end of 1 financial year. If an editor fails to serve notice of meeting to a director, he will be punished with a penalty of fine extended to 1000 rupees. The penalties and all you should by heart. Okay, the penalties are also tested. And what happens, they will ask one provision and they'll link up, right, how much is the penalty, 1 mark. Quorum is dash or 2 director, whichever is higher. one third of the total directors or 2 directors, whichever is higher. See this, 1/3 of the total strength of the board. Total strength of the board. Which statement is not correct? notice should be given to, that means which statement is false. Notice should be given to director even if he has stated that he will not be able to attend the board meeting. Do you remember? Even the director showed his disinterest. Even the original director has appointed alternative director. To each and every director who were registered as a director, the meeting, these notices has to be sent. So it is true. Director has no power to waive his right to receive the notice of board meeting. True. Notice should be given to director even if he can't participate or vote by which of section. Yes. Everything A, B, C are similar only. If a meeting is adjourned due to want of quorum, fresh notice is required to send to each director. Act did not say fresh notice has to be sent to each and every director, provided if there is any change in the place or change in the time, change in the date, the fresh notice has to be sent. Which power cannot be delegated